If you or a loved one has been arrested for marijuana possession in New Jersey, what's going to happen? Hi, I'm Stephen Goldstein. I'm an attorney in New York and New Jersey. And on today's video, I want to explain to you or tell you about what the most likely scenarios or outcomes are of those who are arrested for marijuana possession in New Jersey. On today's video, we're going to talk about small quantities of marijuana, 50 grams or less, because on another video we'll deal with the more serious charges of possession of marijuana with intent to distribute or possession of marijuana in an amount greater than 50 grams. Under the laws in the state of New Jersey, you can be punished by up to 1 year in jail and thousands of dollars in fines if you are arrested for marijuana possession. So what happens after your arrest? Initially, you'll most likely be released without bail, and then you'll get a court date in the local municipal court where you were arrested. On that date, a number of things will happen. Hopefully by that time you will have retained a competent criminal attorney, and that attorney will send in what's called a letter of representation to the court, and that attorney will then get what's called discovery. Discovery in a marijuana possession case would be things like the arresting officer's report, perhaps photograph of the marijuana that you had, and a laboratory report indicating that actually the leafy substance was marijuana. So, what does your lawyer do once he receives the discovery? Well, the lawyer will meet with the client and they'll discuss the various defenses that they may have to the charges. The most common defense in these types of cases is called a motion to suppress. In that, the criminal lawyer will ask the court to throw out any evidence of the marijuana. How does the lawyer do that? Well, he or she can make a number of arguments. Most of the time, or the most common one is that there was no probable cause to stop and search the person who possessed marijuana. On some cases that I've done, it could be that the officers came to somebody's home and without a warrant walked into the house and saw marijuana. It could be that the officers pulled an automobile over, then smelled marijuana in the car, but it was able to be proven at the suppression hearing that there was no basis to pull the car over in the first place. If, however, a judge does not suppress the evidence and it looks like it's going to be a guilty verdict if you do go to trial, then New Jersey has what's called a conditional discharge program. And what that is you're allowed to plead guilty to the charge, and you get put on what's called probation, 6 months to a year, and if you don't have any further problems, the case gets dismissed. This does involve some fines, but the advantage of this program is that you do not have a criminal conviction on your record, and then the lawyer can get the arrest expunged, which means erased. Possession of marijuana charges is not a serious charge, but if you are convicted, you would get the equivalent of a misdemeanor or a criminal record. So, get yourself to a competent criminal attorney, and they'll discuss all your options if you are charged with possession of marijuana. I hope this video was helpful. If you have any other questions, you could call me at the number listed below, or you could send me an email to the email listed below. Thank you for watching.